here comes the role of the tribunals. So, what exactly the tribunal's role is going to be in the process of litigation? See, for example, that you were issued a show cause notice, and then you have filed your reply, and then you have attended the personal hearing, and the original adjudicating authority has decided the matter against you. Then the recourse for you will be to make the free deposit, because now by making a free deposit, the stay is consequential. So you need not apply for the stay separately, but you have to make the free deposit. And once you have made the free deposit and filed your appeal, the stay is automatically applies, and then the matter has to be heard by the appellate authority. But once the appellate authority has also heard the matter and then decided the matter against you, then you are approaching the tribunal. What requires to be done in case the second level of free deposit has not happened? Then that portion also, that you have to make the free deposit and then file your appeal. Then at the time of hearing, that either you or your counsel has to present the matter before the tribunal, and the tribunal will decide. But in the past, what is our experience in this tribunal, in the central excise, service tax and the customs, that there is a tribunal called Customs, Excise and Service Tax Appellate Tribunal. It is called CSTAT. So this CSTAT was there for the central taxes, but state VAT tribunals also used to be there. So the state VAT tribunals used to decide on the VAT as well as the CST matters. But once the VAT has been subsumed under the GST law, only the CST matters remain, for which the tribunal used to function. But very recently, the government has said the existing CST disputes are going to be dealt by the GST tribunals, and all the C-form issues and other things are to be decided in a time-bound manner. That's how the VAT tribunals have completely taken out of the scheme. Now the GST tribunal has to be constituted. But what is exactly the tribunal between the quasi-judicial authorities and the judicial authorities? Because High Court and Supreme Court are judicial authorities. So all the departmental officers are the quasi-judicial authorities. So what is the difference between these two? Is the quasi-judicial authorities are the same authorities who are going to go through your records, find out the problems in it, are the violation of the law or the leakage of revenue, and on that they only make the demand and they only decide the matter. But whereas judicial authorities, the dispute will arise somewhere else. They are independent people, so the matter will be heard by them and they will interpret the law and then they will decide the matter. So this is a very important difference between a quasi-judicial and a judicial authority, because the quasi-judicial authority will also be the authority who is making the demand, and on his demand, he only will be making the final decision, whether the demand sustains or doesn't sustain, by accepting the reply from the party. That is the reason for a quasi-judicial authority, when he is passing an order, it should always be a reasonable order. So there are certain conditions. What is a reasonable order means? Like he should give audience to the party before the matter is finally decided. A proper opportunity to present his case should be there, and he should hear the matter, and he should record the reasons and why he is coming to such a conclusion, that he needs to present it in his speaking order in a very elaborate fashion, by countering the arguments put up by the appellant before them, that why that they are taking a particular legal position and arriving at a decision has to be reasoned. So always a quasi-judicial order has to be a reasoned order. You may say that, see, is it that only the quasi-judicial authorities are bound by the law that they need to pass a reasonable order, whereas the court need not? But in most of the matters, the court need not reason out the orders, that they can pronounce an order which has to be agreed on by all the parties sub judice to them. But whereas in a quasi-judicial order, if the quasi-judicial order is not a reasoned order, certainly that is going to be the primary ground on which an appeal can be filed. So the tribunals are also a quasi-judicial institution set up for the fast, inexpensive, and decentralized adjudication of disputes in various dispute matters such as administrative disputes and tax disputes. So there are administrative tribunals and there are tax tribunals. So the tax tribunals exist in income tax and also in indirect taxes. So there are administrative tribunals which take care of the personal matters. So the tribunals are in both the areas. They function both for administrative and for tax disputes. These are also quasi-judicial institutions. Why do we call them quasi-judicial? Because the tribunal is always a mix of judicial authorities as well as the technical authorities. Who are the technical authorities? They are the subject matter experts drawn from those particular formations. Like, for example, in an income tax tribunal, the bench is constituted by an income tax officer as well as a officer of the court, a judge. So it is a combination of both. So why it is so? That is because that the technical officer will be conversant with the functioning of the department, how the law has to be interpreted, what exactly the field formations understanding on a particular issue. So he can bring the perspective from the departmental side. The judicial officer certainly is going to interpret the constitution and the relevant act and the provisions thereon. Hence, a combination of it is going to give justice expeditiously, and moreover that you need not spend so much of money as it normally happens when there is any legal proceeding in a court of law. So these are inexpensive and it is a decentralized education. Hence, only for the that particular area focused matters only they will be hearing. Hence, it is going to be a faster dispute resolution mechanism. So that is the reason the tribunals were introduced. The original constitution did not contain provisions with respect to the tribunals, but the 42nd Amendment Act of 1976 added a new part into the constitution, which contains only two articles: 323A dealing with administrative tribunals, Article 323B dealing with the tribunals for other matters. The tribunals and courts both deal with the disputes between the parties which affect the rights of the subjects, but there exists some difference between the two, which are as under: for a tribunal, part of the traditional judicial system, but court is part of the traditional judicial system, whereas a tribunal it is a quasi-judicial body. A civil courts have judicial power to try all suits of a civil nature unless the cognizance is expressly or impliedly barred. But tribunals have the power to try cases of special matter which are conferred on them by the statutes. So, an income tax tribunal can hear only the income tax matters. A GST tribunal can hear only the GST matters. A administrative tribunal can hear only the administrative matters of the particular departments that they will mention. Similarly, the courts, the judiciary is independent of the executive, but the tribunals, administrative tribunal is entirely in the hands of the executive. So the quasi-judicial authority creature tribunal is in the hands of the executive, but judiciary is independent of the executive. So the court is bound by all the rules of evidence and the procedure, but the tribunal is bound by the principles of natural justice. So P&J is a very important thing. This is where that you hear at adi altem partem, all these kind of Latin maxims, which say that you have to adhere to the principles of natural justice. Opportunity should be given to both the parties to present their case, and based on their submissions, the court has to reason out that which submissions are having a merit, which submission is not having a merit, and what are the reasons that it is being discarded for not having merits and all has to be explained in the order. So it has to be a reasoned order. Hence, being a quasi-judicial authority, even the tribunal's orders are should be a reasoned orders following the principles of natural justice. So that is what is tribunal, and what is the GST tribunal that we will see. The next slide, please. Pawan, next slide, please. Yeah. In the 53rd GST Council meeting held on 22nd June 2024 in New Delhi, the Council recommended the fixing of monetary limits for filing appeals under the GST. So, for the GSTAT, if the dispute is about 20 lakhs, then only the matter can be heard by a tribunal. Any matters below 20 lakhs, the tribunals cannot entertain the appeal. High courts, it is 1 crore. Supreme Court, it is 2 crores. The GST Council also recommended reducing the amount of pre-deposit for filing appeals under the GST. So accordingly, the maximum amount for filing appeals with the appellate authority has been reduced from 25 crores each of CGST, SGST to 20 crores each of CGST and SGST. And the amount of pre-deposit for filing appeals with the appellate tribunal has been reduced from 20% with a maximum amount of 50 crores each of CGST, SGST to 10% with a maximum amount of 20 crores each for CGST and SGST. So, in order to clarify the matters, at the first level, when you receive an order against which you are going in for an appeal with the first appellate authority, 7.5% of the disputed amount is what is to be pre-deposited. But at the second level, when you are going in for a second level appeal, then the balance of 2.5% is what requires to be redeposited. But this 10% has got a maximum cap of 20 crores in CGST and 20 crores in SGST. So total money paid is going to be not exceeding 40 crores in a dispute. So much of money has to be deposited and then the appeal has to be filed. These are some of the important amendments that were made. Next slide, please. Yeah, GST Appellate Tribunal composition. Before going into the details of it, that let me tell you some interesting things. Why at all the tribunal is taking so much of a time, everybody may think. But the erstwhile Central Excise Act and all, if you see that after the enactment of those acts, Central Excise and Salt Act is 1944, even before independence. But the Customs Act is 1961. But the SEGAT, the earlier form of SESTAT, was convened somewhere in 1978 or so. So it took so many years for the government to conceive the idea that there should be a tribunal for faster settlement of the disputes. So compared to that kind of a legacy in the GST, after the introduction of the GST from 1st of July 2017, now in 2025, that is after 8 years, we are now going to see the tribunal's constitution. So the tribunal under GST has been formed with much more with faster pace when compared to the erstwhile laws. So everybody is saying that why the tribunal is getting delayed, but if they go into the history of the indirect taxes of the past, for the central excise or the service tax or the customs, the tribunal was formed after decades of the law being in force. But in the GST, just within 8 years itself, the GST tribunal is going to take shape. I do not know when it is, but at least now it is 8 years that, but certainly that we are going to see the light of the day. So this tribunal formation itself was taken for a ride by filing of several appeals in high courts as well as in the Supreme Court. And Madras bench has fought for the rights of the advocates as well as for setting the tribunals in the right frame as per the existing understandings, and they won at several places. Ultimately, the formation of the tribunals now has taken the final shape. Of course, now the GST Appellate Tribunal is a composition which includes a national bench situated in Delhi and constituting the president, a judicial member and a technical member, one from the state and one from the center. Further, there are 31 state benches consisting of two judicial members, a technical member and a center, and a technical member from the state. So, what is this? Every tribunal has to be having at least 4 members. 2 are from the judiciary, and one member is from the CGST, another member is from the SGST. So there will be 4 people in a tribunal. So such 31 state benches will be there. And in addition to that, there will be a national tribunal, which is going to be national bench, which is going to be situated in Delhi, for which the president is going to be the judicial member. And in addition to him, there will be another judicial member, and then there will be a CGST member, and then there will be a SGST member. That's how the tribunal's formation is going to be. The tribunal is not bound by the Code of Civil Procedure 1908. Of course, the CPC has undergone a change very recently in 2023. The new law has replaced it, but follows the principles of natural justice and has the authority to regulate its own procedure. The tribunal possesses powers similar to the civil court under the CPC for matters such as summoning individuals, demanding document production, receiving evidence and affidavits. The tribunal can requisition public records, issue commissions for witness examination, and dismiss or decide representations for default. Orders issued by the tribunal can be enforced as if they were court decrees, with the tribunal having the authority to seek execution within the local jurisdiction. All proceedings before the tribunal are considered judicial proceedings, and the tribunal is deemed a civil court for specific legal purposes, aligning with sections 193, 228, and 196 of relevant legal codes. So these are the important attributes of a tribunal. So this GST tribunal is no different. It follows all these rules. Next slide, please. So now, what are the issues that we have for the functioning of the GST? Appointment of members. See here, what is happening is that all these persons, so that now we have got a CGST member, SGST member, and then judicial members. So the judicial members are to be appointed by the central government. All the CGST members are to be drawn from the CBIC, Central Board of Indirect Taxes and Customs. Then the SGST members are going to be the persons who are there in the SGST department of the respective states. So every state has to make a search committee. There is a set procedure how a member has to be selected. So they have to call for the willingness of the persons who are working, and then they have to scrutinize their applications, and then they have to shortlist the candidates, and then they have to do the background verification of them, and then they have to get the NOC from the department to relieve him, and then he should be given the appointment as member of the GSTAT. So this procedure has to be followed for each and every member who is going to be selected from the SGST or the CGST or from the judiciary also. So it is a mammoth exercise. You may think that there are only 31 benches, state benches, but each state has to do this exercise and complete it in the given time. And after that, in some states, because of the number of cases that may come, that they have allotted more than one bench. So in all such cases, they have to increase the number of members also, and then they have to provide the infrastructure to all these members. And then a government officer has to function means he needs to have an office, he needs to have his subordinates, he needs to have a vehicles and other things and all. So all these are to be provided by the respective states. So it is taking its own time. And then the government, in its efforts to digitize things and not to deal with the paper, so they said that all these filings for the GSTAT are going to be online. And to the extent possible that they have amended many laws. Now the original hearing of the show cause notices is happening online only in most of the cases, only when it is mandated that either the adjudicating authority or the arguing counsel is specifically desires that it should be a physical submission, then only that they are entertaining. So online is by default, and physically appearing before the authority for personal hearing is by choice. So that's how it's happening. But as far as tribunals are concerned, that they want to digitize the whole process, hence they said it is going to be online filing. So there are doubts in the minds of the people that the website address has been given, but whenever we click that website, it is not functioning. That is because that the minute it starts functioning, that people try to file their appeals. So, but the infrastructure is not in place. The adjudicating members were not yet appointed in some states. Hence, they have not made it operational. That is the reason the GSTAT Tribunal website, that you may be seeing it, but it will not function till the time it has been announced that the tribunals, all the members are in place, and the tribunal is going to start functioning from an appointed date. So the notifying the start date is very important. So that one has to wait. So now people have doubts that when their matters have passed the original adjudicating authority, the first level of adjudicating authority, or in some cases the second level, but however, that the matter now has come wherein that they have to file an appeal with the tribunal only if it is in existence. But in the absence of a tribunal, what requires to be done? This is a bigger question for many people. So, because the tribunal is not yet constituted or not yet functional, the government has come out with a clarification that whatever is the pre-deposit that requires to be paid for the matter to be heard, if you have already paid the pre-deposit, the minute you pay the pre-deposit, it is automatic understanding that the stay applies. So your case has been stayed. So there will be no recovery proceedings in all such cases. Hence, that the mere filing of the appeal with the tribunal is the only formality that is remained. Hence, the department is saying that you can file a letter with the department saying that you intend to file your appeal with the tribunal, which has not been in existence. However, whatever is the pre-deposit that requires to be paid in order to get the automated stay that you have already paid, and you enclose the payment proof, and then you just file this letter, that is good enough. So as and when the tribunal gets constituted, till that point of a time, there will be no recovery proceedings against the demand that was made. Hence, the people can wait till the tribunal comes into the existence to file their formal appeal, and the matter will be heard and the decision is going to be given. So such a kind of a facility has been given. So Maharashtra is the first state to issue instructions on these lines. Later, some other states have taken the cue, and ultimately from the CBIC also, such a clarification has come in the form of a circular. So one can refer to that. So any matters which are to be appealed with the tribunal, that you can make the pre-deposit and then submit a simple declaration letter with the department saying that you are waiting for the tribunal to get constituted, but the pre-deposit has been made. Hence, your matter is already stayed till the constitution of the tribunal, and you file the appeal and submit the proof of that appeal and all that. Till that time, there will be no recoveries. So that's how the issue has been addressed. However, despite of these instructions, if somebody is facing any kind of a recovery proceedings and all, then that has to be dealt with in a separate manner. So, because that should not be ideally done, but if some authorities are resorting to such a kind of a thing, then it has to be dealt in a separate manner. But the instructions are very clear to the field formations as well as for the SSCs also, that there should not be any coercive measures to be undertaken. The second aspect I just wanted to touch upon is many people are of the impression that we do not know when the tribunal is going to form. Till that point of time, my board of directors are not going to leave me. I, being the tax head, I'm responsible even to resolve this issue. Hence, why not that I go to the High Court? See, going to the High Court or the Supreme Court in the form of a writ is seeking the extraordinary jurisdiction of those forums. So the high courts or the Supreme Courts are going to entertain your writ only and only when the regular mechanism failed in performing its duties, or there are serious demands on you for which that you can't wait for the tribunal to get constituted and matter be heard and then ultimately get resolved. So the special circumstances in which they can invoke their extraordinary jurisdiction is something that has to be impressed on at the time of admission hearing. So unless you succeed in that admission hearing, your writ is not going to be entertained by the courts. So the courts will say that when you have got the normal channels of your appeal mechanism, as I told, the original level, first level, the second level, and then the tribunal, and then only to the High Court, if need be, or the Supreme Court. So why you are not following that the normal mechanism that has been given, that going by the hierarchy of the appellate authorities, and by skipping one authority, why are you knocking on our doors? That too to invoke the extraordinary jurisdiction of those courts. So unless you justify that point, that simply that since you have got money, if you want to go and file a writ, it's not going to happen. And in most of the cases, the biggest other problem that we are facing is some of the courts are having very active tax benches. So they entertain your writ and immediately pass the orders also, and it becomes a sensational sometimes, and then the matters are traveling to the next forums like that. But in some of these states, we could see that the tax benches are not getting constituted on a periodical basis, and many matters are kept pending. So because of that reason, that if you are, unfortunately, if you are staying in such states, then what is happening is all these writs that you file will be there in the filed state only, that the matters are not moving. Hence, you will not get any kind of a justice. The only thing is that you can go to the department and say the matter has been appealed, and then the matter is pending with the court. Hence, that there should not be any kind of a recovery. But the unless there is a stay, then the field formations may not stop their recovery proceedings. So that is the reason you can always cite the CBIC circular, which says that once you make the pre-deposit and file a simple letter saying that you are intend to file a appeal with the tribunal, then the recovery proceedings should not be initiated against you, that the recovery officers will be behind you. So that we need to keep it in mind and act very judiciously. But knocking the doors of the High Court or the Supreme Court in the form of a writ is not a default way, because the tribunal is not yet constituted, because it is very unlikely that your matter may not fit into the special circumstances in which the courts will be exercising their extraordinary jurisdiction in order to entertain your writs. So keep that in mind while advising your respective managements. Otherwise, what happens is that you do an exercise which will become futile. And if the court ultimately, after taking its own time, decides that you should have gone through the normal channels, then whatever time that you have spent in this frivolous litigation is going to be lost. And every day in the litigation proceedings is very important, because the interest burden will be mounting on you. And under the GST law, the interest, you know it is 18% in all normal course. But if it is a misuse of your ITC, it is going to be 24%. I don't think that any business is making so much margins in order to meet the interest liability. Hence, your decision to your management should be on reasoned grounds. So think twice before taking a decision to go in before a high court by bypassing the tribunals, though they were not constituted, but that is the way in which one needs to think. Next slide, please. So the way forward that we have is, there is no indication about the start date of functioning of the tribunal in the recent budget presented on 1st of February 2025. Lot of changes in the hierarchy of the relevant authorities have happened, that you know it, that in quick succession that we have got we are now going to have the third revenue secretary, and the states have to yet to appoint their SGST members, and center has to appoint their CGST members also. And you know it, once it is a May, then it is a season for transfers and all that, and then there will be promotions. Hence, we need to see if somebody is appointed a member, and if he suddenly gets a promotion, then he will relinquish this appointment, then he will go for the regular promotion and all that. So such kind of dynamics are also there in the play, and provision of infrastructure by all the states is not yet over, and creation of a functional website for the online filing of the appeals is still pending. So with these many problems that the tribunal functioning is not yet happening, hence we need to wait and watch when it is going to be the day when this online filing can happen and the tribunal really starts functioning and starts dishing out the needed justice for us.